Attention students, there has been an outcry amongst other students that I should be teaching you ways of drafting summons or court documents. I agree with that sentiment, but what I can say as an advice is that the best thing is for you guys to practice all the time. You practice as to how you draft your documents, the court documents. It is important because that's where you will see professionalism. You cannot, there's a certain way, a prescribed way of drafting documents. You can't use your let's say funny, or is it maybe you try and decorate it or make it appealing, but there's only one standard manner of drafting documents. What is important is that for each and every document, there must be what is called a heading. Right? A heading is, I will describe to you what the heading contains. Right? The heading should specify which seat of the court is going to adjudicate this matter. How do you do that? You write in the district court of Empangeni, held in Empangeni. Now we know exactly which court will be adjudicating. You cannot go to a court in Durban when the heading there says in the district court of Empangeni. Because remember, you will now be working in a law firm where there will be cases for various courts, and you will be given this brief, maybe by your principal. He will give you this particular file to go and attend. So you need to know which court am I going to. That is why now you have to have, even if you are drafting, you draft in the district court of Empangeni, held in Empangeni. Right? And the next important thing, after you have done that, on the right hand side, just below that heading where you've mentioned the head of the court, then you must then write the case number. So you'll say, sometimes you'll see some cases written RC if it's regional court. R stands for regional and C is court. So you'll say RC 2022 of 2022. That is now the case number. So when you go to court, you will be, like I've told you when we did divorce, I said, when you get to court, you will just confirm your appearance, and you must also state what case number are you appearing for. Then you will say, I confirm my appearance for the plaintiff on case number 2022 of 2022, right? So that you've got the case number. It is very important. And also make sure when you are writing that case number, because in the subsequent documents in that file, let us say, for instance, you are now drafting a notice of set down. You need to make sure that you don't, if you have said the case number is 2022, you can't say 20 or say 220022. It must be 2022. There's only 1 0. Once you put an extra 0, then you must know that you've caused chaos in that case, because it will be lost and you will go to court. It will go to a wrong file. Let us say maybe your case number was 123 and you mistakenly write 1123. You write the 2 1s instead of 123. And there is a case that is 1123. So that means that document will go to that wrong case number, and everything is chaotic. You will say you have filed, only to find that you filed, but you filed on a wrong case number. So it is important for you to double check your case number before you file, because sometimes when you come to the filing clerk or the registrar's office, you'll find that there's a long queue and it's busy, so you need to know what you are here for. The clerks, they won't be looking. They will just take it and put a stamp and hope that they will file it later. That is what they normally do. You bring your summons in, they take it, they look at it, they see you've got your case number, you've got everything in order, then they just stamp it and give you your copies, and you are gone. They will file it later on, only to find when they file later on, they are filing on the wrong case number. So it is important for you guys to check your case number in order to avoid chaotic consequences, right? That the document which you file in court, it is not placed in a wrong file. That you need to check all the time, right? Also, you must also check that the party or parties must be indicated as to who is the plaintiff and who is the defendant. That means you must write so and so is a plaintiff and the defendant is so and so. You need to indicate that when drafting the heading, because by heading we mean the very face of that of the summons that you are drafting. You will have the seat of the court, that is the name of the court, whether it is a magistrate court, district court, or regional court, or high court. You need to state and you state the case number, and you also state the parties. That the party number one or plaintiff is Mr. Sneller, and the defendant is you state the name of the defendant. Right. Make sure that when you write the parties, you don't just say Masondo, the plaintiff. You need to write the full name of the plaintiff, and also do the same thing with the defendant. You write the full name, because there could be so many Masondos, right? So you need to differentiate. This is Enoch Masondo and this is Paul Mdleje, who is the defendant. So you need to specify that. It is important so that you avoid confusion, right? Then there will be a heading where you need now to identify the type of the document. What document is this? Is this a founding affidavit, or is this a supporting affidavit? So you will draw two lines. Between the lines, you will have that is now the subject matter. That is now identifying the matter before court. What is it? Is this, sometimes you say, an application for default judgment, or you just write the plea if it's a plea. So everybody knows that this document is a plea, this document is a founding affidavit, this document is an application for default judgment or plea or a founding affidavit, like I've said. So it is important to do what? To differentiate the type of document so that it can be easily identified. As I've already indicated to you, that the golden rule for the proper drafting of pleadings is that you must consult with your clients properly, so that you know this case in and out. You have got no doubt as to what area of law, what law is applicable to this particular problem. You need to do that. Even if you are a defendant, then you will know exactly which method you are going to apply, right? And the main points that you will need for the defense, that is now if you are a defendant. So it is important to consult, right? You must consult extensively. Don't just take things for granted. And also, you need to allow your client to say everything. Do not interrupt unless you want clarity. If your client says anything and you don't understand, then you can maybe apologize and just say sorry for interruption, but I did not understand this point. What do you mean by this point? And because like I'm saying, it is important to consult extensively and make sure that you understand everything that is being said by your client, right? And like I've said earlier on, that you must guard against mentioning unnecessary and immaterial effects in your pleadings, because that will annoy the magistrate or the judge. So make sure that whatever you say is going to help the case. Do not listen to the emotions of your client, because clients come to you emotional. They want to say everything, but sometimes they say irrelevant or immaterial things that are not going to help their case. But you need to guard against that. But make sure also that sometimes you will find yourself quoting a section, right? And if you quote a section, you need to make sure that you quote it fully in your pleadings. Do not just say section 4, and the court will say, but section 4 of what? So when you are referring to a section in your, let's say, legislation, you need to state that this is section 4 of the Credit Agreement Act. If the parties are fighting over, for instance, sometimes you get cases where the bank is owed by your client, right? And once if you want to, either you are for the bank or you are for the defendant, you need to state the section 4 of the Credit Agreement Act of 1978 of 75 of 1980, right? So that the court knows exactly, if they want to refer, they will go to that act and see what are the provisions contained in that act. So it is important. And also, if you want to quote a case like the case that I've given you, King versus King, volume 2, you also quote, and the pages where you will find that principle. We said 630, so you go to page 60 of that case and find what was the principle. It's all about emphasizing the need to state your case correctly.